Welcome, everyone. Thank you for joining us for our virtual Hospitality Law Conference. Wow, interesting times, but it does look like we're heading in the right direction. Hopefully the trend will continue with the news that New York City is opening up, I believe on May 19th. I think that's a good sign for everybody and hopefully many people included in this program today. So we've got a lot to talk about. Some exceptional thought leaders are joining us, and we want to get right to that. So beginning our conference this morning, joining us as usual, Andria Ryan, partner, the Fisher and Phillips law firm. Andria and the firm have a national practice representing employers. Andria is the co-chair of the Hospitality Industry Practice Group and a member of the F&P COVID-19 Task Force. Joining Andria today will be Mr. Nick Hulse, Associate Fisher and Phillips out of the Charlotte office. Nick is also a member of the firm's COVID-19 Task Force, and he focuses a lot of his time on assisting employers with workplace safety matters. Nick also is involved in a lot of litigation challenges that employers face. They're going to be kicking us off today talking about workplace safety. COVID complaints are on the rise. Don't take your foot off the gas too early. Please welcome Andria and Nick.
Stephen, thank you so much. And you all, I miss seeing you in person. Always enjoy it. And I'm hoping we will all be together the next conference. But here we are, me again. We're going to dig into some safety issues, some litigation issues. We're going to worry you a little bit in our session today. What I want, excuse me, what I want to Colin here in Atlanta, to remind you of is we've all become experts, right? We became experts, lawyers and business people alike. We became experts on a virus, on when a virus becomes a pandemic. We became contact tracer experts. We became quarantine experts. We're now becoming vaccine experts. But it's not over. And I think that's really the theme of our session today. It's been a bit of a roller coaster, as I say here on the screen, but we've got local surges, we've got vaccination issues, we've got positivity rates trending. We're still having challenges getting employees back to work. People are still afraid. Many are still afraid to return to work. And it's really a time, again, we can't really coast through the end of this. We're shockingly seeing a rise in lawsuits. When we, if we look back to December of this year, they were starting to trickle in COVID-related lawsuits, and now we're seeing a bit of a flood of them. Near the end of our PowerPoint presentation, I will show you a spot on our website that we're tracking on a daily basis COVID litigation. So if you want to worry yourself just a little bit more, you can go to that spot and see where they're filing them, with a brief description of the cases, what state they're being filed in, and what industries are being hit. So again, don't want to over concern you, but we do want to make sure you're not taking your foot off the gas. We're going to talk about two things today. OSHA inspection and whistleblower. I'm going to let Nick lead that discussion, and then I'll come back to you and we'll talk a little bit about some of the COVID-related litigation, what it looks like. And then of course in our Q&A, we want to be really practical with you and talk about some some cautionary things and some measures you can put in place to try to avoid being one of these litigants. All right, Nick, it's you.
Perfect. Thank you, Andrea. Good morning, everyone. The Biden administration has promised to make OSHA a much more aggressive agency under his administration. He plans on doing that by doubling the number of OSHA inspections. As part of this new aggressive approach, OSHA released a national emphasis program that will prioritize COVID-related inspections, especially for work sites where there have been COVID-19 related deaths or multiple hospitalizations resulting from employees catching it at work. OSHA's goal with the NEP is to reduce or eliminate worker exposure to COVID-19 by targeting the industries where employees have a high frequency of close contact with either their coworkers or the public. And a lot of people in the hospitality industry will fall into that category because of the interaction that your employees have with the public. So it's important to take note of that. OSHA, as part of the NEP, specifically identified the industries that it's going to target, which is helpful. They include supermarkets, both full service and limited service restaurants, where employees are kind of interacting with the public throughout their shifts. How it's going to work is employers that are in these specific identified industries will be placed on a targeting list, and then OSHA will just go down the list and conduct programmed inspections at these work sites at a randomized process. So if you're in one of the industries, you're going to end up on the list, and then it's totally random of when or if OSHA does show up under this program. So if you're on the list and OSHA does show up, you're probably wondering, what will they be doing? Well, the first thing OSHA is going to do is they're going to review your written safety and health plans, your procedures for identifying hazards in the workplace, including how and where employees may be exposed to COVID, and your protocols for personal protective equipment use, such as, are you requiring employees wear gloves, face coverings, are you putting physical barriers to protect your employees? So that's the first thing OSHA is going to look for. So it's important that you have a written safety and health plan that not only covers COVID issues, but while OSHA's there, they're going to be looking for violations of other OSHA statutes. So make sure that you have that written safety and health plan for your employees. Next, OSHA is going to walk around your work site to determine what measures you've put in place to facilitate physical distancing, and whether the latest CDC guidelines are being implemented and followed. So even if your locality has lifted physical distancing requirements, OSHA's position is still that for your employee safety, that you need to be following social distancing requirements. So make sure if you had signs up encouraging employees to socially distance, make sure they're still up, because that will be stuff OSHA's looking for.
Nick, before we go on to the next, some of these discussion of these standards, let's just pause for a moment and talk a little bit about workers' comp, because I think we've just put an alert out today about this. You know, are people hesitating to include COVID-related incidents on their OSHA reporting logs because they're worried about having to file workers' comp claims? You know, it's a little bit confusing. Let's talk about the OSHA part of it. Should there be any hesitation? I mean, I know I didn't, warn you that I was going to ask you this, but should we have any hesitation for folks to be keeping those kinds of important records?
No, so there should be any hesitation, mainly because it's a statutory requirement that if you determine that an employee contracted COVID at work, and they missed work, or you had to transfer them to a different job, that it goes on your OSHA 300 log. So any hesitation related to workers' comp, it may cause a bigger issue in the end of OSHA coming in, looking at your logs and saying, where are these cases that we know happen? So there shouldn't be any hesitation because it could lead to even bigger issues with OSHA issuing you a record keeping citation or something like that. And just because it's on your OSHA log doesn't it isn't the end all be all of workers' comp. So
right. And I've been recommending to companies, workers' comp is a protection for you. I know we all try to keep our costs low, but if it's you reasonably conclude that one of your employees contracted the virus at work, let your insurance company sort that out. You're better off filing it and letting them sort that issue out. So anyway, thanks, Nick. This is your slide as well on these OSHA safety standards.
Yeah. So knowing that OSHA could show up, you're probably wondering how can you prepare if OSHA does show up. So the most important thing to do is staying up to date on OSHA's latest COVID-19 guidance. Since the Biden administration took over, they've been more proactive in releasing guidance. The OSHA's latest guidance very specifically stresses the importance of having a COVID-19 prevention program. In some states, such as Virginia and California, they pass statutes or standards that specifically require a written prevention program. And the latest federal OSHA guidance seems to be that they're trending in that direction. So if you have COVID-19 policies in place for your employees, consider consolidating them into a comprehensive prevention program, kind of putting them all in one place. That's easy to show to OSHA and for your employees to understand. OSHA also recommends that you do not relax your preventative measures for employees who have been vaccinated. I know that there's a big push for that, is kind of what's the point of being vaccinated if we can't relax our preventative measures. But OSHA's current position is that until more is known about how vaccinated individuals carry the virus or don't carry the virus, and kind of how many of your employees have been vaccinated, OSHA recommends that you don't relax those preventative measures. So keep that in mind. That could also cause problems if OSHA were to show up. Some final key points I'll point out. OSHA still recommends that employers require face coverings. So even as your state or local government relaxes those mask mandates, you still have a duty to protect your employees. And under OSHA's guidance, that includes them requiring them to wear face coverings. So OSHA could still show up and cite you if your employees are not wearing masks, even if it's not required in your state or locality. Same with social distancing requirements, which that's going to be very tough as kind of everything opens up 100% capacity. You're going to have to weigh capacity issues with maintaining that social distancing that OSHA is requiring, because OSHA could show up and say there's no social distancing going on here and issue a citation. So for the time being, just keep in place what you've already been doing. Hopefully we're towards the tail end of this and OSHA will begin to relax their guidance, but for now they have not. So just keep doing what you've been doing, and just in case OSHA does show up.
Nick, what do OSHA penalties look like? Give us a range of what we could be looking at here.
So they can issue anything from other than serious, which I believe can go up to a $10,000 fine, all the way up to willful if you know your employees are exposed to a hazard and you don't do anything to prevent it, and OSHA finds that you don't really care, they can issue a willful citation, which I believe the penalty is up to $70,000. And if it gets bad enough, they can prosecute you criminally. So it can get pretty bad pretty quick.
Yeah. Before I go on to some of the other litigation trends, I wanted to mention that all of us in the firm nationwide are seeing a serious uptick in whistleblower complaints, especially under OSHA. So your employee, thinks you're not, handling COVID protocols properly, or you're not following your own safety guidelines, or these, this list you're seeing here on these COVID safety standards, and they start calling around, right? They call the EEOC. The EEOC says that has nothing to do with us. They call the Department of Labor. That has nothing to do with it. They finally find their way to OSHA. And, as soon as they make a complaint that says, I've been raising this issue with my employer, I've been complaining about it, and now I've been demoted, taken off the schedule, which is effectively a termination. I mean, I know we often use that. A lot of folks use that as a disciplinary measure, but taking somebody off the schedule is potential retaliation, or certainly separating or terminating an employee. We're seeing a real increase in whistleblower OSHA retaliation complaints, like we've never seen before.
Yeah, and I think a lot of that stems from the messaging that the Biden administration has put out about how aggressive OSHA is going to be and looking into issues like that. So yeah. I think it's kind of giving employees a newfound boldness to make those complaints, and actually they may go somewhere now under the new administration's messaging.
Yeah, that's a good point. And it's not taking them long to find the right agency. So to keep us moving, because we have a short period of time, I want to talk a little bit about the litigation trends that we're seeing on the federal level. We have the Family's First Coronavirus Response Act, which is now voluntary. If you are giving leave under this law, you're doing it on a voluntary basis. The problems that we're seeing here, number one, we have some leftover litigation. Folks that wanted leave before or feel they're being retaliated against for taking leave in the past when it was required for smaller businesses. But the other thing we're seeing now is folks who are wanting to give paid leave for only certain kinds of absences. So if you're going to be absent because you're sick yourself, or because you're going to get a vaccine, which we really want you to do, we'll give you the paid leave. But in other situations, we're not going to give you the paid leave. You don't have that choice. If you were going to voluntarily provide leave under the FFCRA, you can't distinguish between the type of leave. And I know a lot of folks want to encourage people to get vaccines and give them the benefit of this law in order to do that, but we can't do that. We're also seeing plaintiffs' lawyers get fairly creative about their lawsuits, right? They're looking at violations of public policy, retaliation type whistleblower complaints, negligence complaints. We've seen a few wrongful death complaints, which plaintiffs' lawyers are arguing that that the employer, was either grossly negligent or willfully allowed somebody to be exposed and didn't protect them. And then a handful of states have passed their own COVID-related sick leave laws. So if you're in all those beautiful, truly beautiful states like Colorado and California, you need to be careful about the sick leave laws that have been passed and make sure you're in compliance with those. So those are sort of the trends we're seeing.
And just to jump in real quick, off that litigation, if the best defense you're going to have to a negligence claim or something along those lines is demonstrating that you were following CDC and OSHA guidelines. So that's just to pile on top of the importance of following the OSHA guidelines and having it documented that's going to be your best defense in one of those actions.
Yeah, good point. So go back to next slides. We'll tee up the issue of vaccines, and we're happy to talk about it. And we presume some of you will have some questions about this. We did a flash survey in February, and we had, these are the findings. The vast majority of employers are not considering mandating the vaccine. 27% of the time were unsure, and 9% of employers were considering mandating the vaccines. A recent survey that we didn't conduct, that I saw conducted in April, that number's gone down to 3% of small businesses. So I think less and less employers are considering mandating, but they're really struggling with how to get their staff to be vaccinated. Can they ask questions? Can they keep a log of people that are vaccinated? What if they have groups or guests that are requiring only to be assigned employees who have been vaccinated? How do you gather that information, and what do you do about it? So I think we're going to see a lot of employee relations issues arise out of this vaccine issue. The EEOC indicates that you may require your employees to get vaccinated. We are certainly expecting any day now some EEOC guidance on what incentives for vaccines. A large employer group asked the EEOC to please provide some guidance on what we can give employees to incentivize them to get vaccinated. So we're expecting some guidance on that. So keep your eyes open for that. If you decide to mandate vaccines, you must build in a process for reasonably accommodating anyone that has a medical condition that will prevent them from being vaccinated, or for religious reasons. We've been dealing with this and with the flu vaccines in healthcare for many, many years. So it can be a fairly sticky situation if someone says, I can't or I won't get a vaccine because of my medical condition or their sincerely held religious beliefs. And of course, monitor your state legislatures about restricting vaccine mandates or restricting inquiries about vaccines. No state prohibits mandatory vaccines. Oregon has some restrictions, but we will not be surprised if we see a few more states sort of trickling in this area. The other thing I'd urge you to look at is your state's liability shield laws. Many states, about 19-20 states, have in some form passed a liability shield law, and they all have their variants, and nuances about what kind of steps that you take if you're properly following, as Nick mentioned, earlier on the negligence claims, if you're properly following CDC and OSHA guidance, you may be able to shield yourself from liability if a guest, a visitor, a member, or an employee contracts the virus or argues they contracted the virus on your property. So it just lends, more credence to that need to be prepared and stay compliant. This is the slide that I was telling you about. I uploaded this a couple of days ago into the PowerPoint because Taylor made me send it early. Today, I looked at it today. There are now 2,293 cases filed that are COVID related. We're doing this on our website daily. So again, if you want to worry yourself just a little bit here and there, and visit it every once in a while, we call it the Litigation Tracker. As you can see, I want to point out a couple of things. There's a handful of those heavy red states are where we're seeing the most litigation. Not a big surprise. We're always a little bit surprised about the amount of litigation in Texas, but they are certainly big enough that they garner a lot of litigation. But remote work and leave conflicts is the most common case that we're seeing. Healthcare is obviously getting hit the hardest, but if you can see on the company size grid at the bottom, the largest number of cases are being filed against small employers. So if one of you out there is, as many of you are, I know from our previous meetings, a smaller operation, you're not out of the woods here. I looked at the National Federation of Independent Businesses survey that was done in April. Half of their employees, one half, and this is 550 small businesses, had taken some form of leave as of April. And that was only 25% in December. So more and more people are, as I said, these leave conflicts are a real huge source of litigation. So be careful when having employees requesting leave or COVID-related time off. And then our last, just a reminder, just to give yourself a bit of a checklist, stay educated and your leadership team about federal and state restrictions. Again, we've become experts in all kinds of things that we never thought we'd be able to, and here we are again, COVID safety protocols. It's probably a good time right now to conduct a good walk around, feet on the ground safety protocol review and make sure your employees, if OSHA were to come in and interview them, would be able to say what your policies are, in a meaningful way and describe them and say that they've been trained on them. We want your folks, if asked, to be able to speak clearly and convincingly that they are up to date on what's expected of them. Make sure you're looking at your leave of absence and furlough issues. It's probably time to make a decision about what you're going to do about vaccines. How are you going to handle gathering the information from your employees, keeping an Excel spreadsheet, keeping it confidential, and how you're going to respond to, especially, again, the most common question I'm getting is groups that are requiring employees to be vaccinated to work at their events. So it's probably time to move forward on your vaccination policy. And with that, we will open the floor to questions, Stephen.
Thanks, Andrea. Thanks, Nick. Wow. Great stuff, but holy moly, a lot to think about. My goodness. Wow. Let's see, before we leave this slide, Andrea, you've got educate yourself and your leadership, federal and state status. On y'all's website, are you tracking all the different state legislation?
Yeah, we're tracking a lot. We've got a vaccine tracker. We've got our COVID website. We're so proud of it.
Yeah.
Our COVID landing page is updated daily. And again, both Nick and I serve on the task force. We also have a vaccine task force. I mean, we have got task force for this pandemic like nobody's business.
Well, do us a quick favor, if you will, either you or Nick, just in the chat, just send the URL to your website, just so that everybody will have that and they can copy it and then have it as an enormous resource. And ladies and gentlemen, feel free to unmute and ask a question or to send it through a chat. I've got a couple of things I'd like to ask right away. But before I do, I'd like to remind everybody that we'll be doing a survey after each program today for your CLE credit. So don't leave right away. If you're interested in CLE, you'll need to respond to that survey so that we can verify your attendance and know the different states. So thanks for that help. And then also want to remind you that we're planning on getting face-to-face in Washington, D.C. back at the Army-Navy Country Club on October 6th, the Wednesday, October 6th. It's going to be a hybrid program. You can join us in person or online, and you'll be getting more information. Just wanted you to save the date. So one last thing is Andria was kind enough, and her team were kind enough to create a video on anti-maskers and how to deal with anti-maskers. It's a fabulous training tool for all of your locations, and it's located on our blog at the Hospitality Converge blog at HospitalityLawyer.com. It's 15 to 20 minutes long. It's combined with a very cool article that they did laying out step by step on how to train your employees and have them learn to de-escalate situations with anti-maskers. I'm bringing this up because I've been reading lately more and more about some real challenges that we've been having to this day with anti-maskers. So I just wanted to make you aware of that resource that Fisher and Phillips has provided as well. Okay, so back to the questions, Nick, if I may. Nick, can you talk a little bit more about the litigation that's going on and bring in the workers' comp concept and the workers' compensation bar to some of these negligent type claims? Can you spend a few minutes talking about that for the folks?
Yeah, definitely. So if an employee is injured at work, it's covered by workers' comp, but many states have ways to get outside of that if they can prove that the employee, if the employer was acting negligently and that caused the employee's injury. So in the case of COVID, if you don't have any COVID policies at all, your employees are just running amok, and God forbid an employee dies from COVID that they got at your workplace, then that could move it outside of the workers' comp world and get you into litigation where you could be held liable outside of your workers' comp insurance. So that it's important to have those policies in place to keep it within that workers' comp world where it's covered by your workers' compensation insurance and doesn't move you into the more formal litigation where you could be held liable. So just another reason to have those policies and keep them in place moving forward. A lot of people think that COVID's over. There's still flare-ups happening all over the place. So now is not the time to relax, or you could be opening yourself up to some sort of litigation outside of the workers' comp world.
Yeah, and Nick, if that's the case, then if somebody does figure out a way to overcome the workers' comp bar, would our general liability insurance policies drop down to provide coverage? Or obviously there could be, like we're seeing with the business interruption exclusion, right? They're pushing, the insurance companies are pushing back on those claims. Or what are you seeing if you have, if I know I'm hitting you cold, but on the insurance side of this, outside of workers' comp, is there some coverage?
So I haven't seen the issue come up yet, but knowing insurance companies, I'm sure they will push back on that and argue that you weren't doing your duties under the contract. You knew this hazard existed and you didn't put those preventative measures in place, so therefore you're not covered. So there is that risk where they could push back saying you knew the risk, you have a duty to minimize those risks under the contract, and you didn't take those necessary steps.
Yeah, that's terrific. Thank you for that. Okay. Andria, to you on the vaccine question, we're going to get some guidance on incentives. That's going to be helpful. I was reading the other day that some public safety folks are offering $100 for people to get vaccinated, and it seems to be working. So clearly there's something to the incentive, and then we've got to figure out how that fits. But the question I have for you is, it's clear that we can say, yes, you must be vaccinated. Question is, do you want to, right? You've laid that out very well. But here's the question. What if somebody that works for you says that it's like the remote employee thing, but at the restaurant level or the hotel level, I don't want to come back to work unless I know all of our customers have to be vaccinated as well. What do we do about that?
It's similar to I'll say similar to the question, if you were to mandate a vaccine and say to employees, what are you going to do with the employee who says, I just won't do it? I'm not going to do it. It has no religious reason, no medical reason. I just don't want a vaccine. What are you going to do with that employee? It's really the same answer. And that is, you can put them on a furlough, you can lay them off, you can put them on a leave of absence, you can terminate them. It's a tough decision to make. But I have the handful of clients who are mandating vaccines. And for those that refuse the vaccine are trying, other measures, right? Limiting their work area, limiting their workspace, which is difficult in a restaurant or many hotel jobs. Obviously requiring a mask at all times, even with some relaxed mask mandates, or leaving them out of the workplace until the pandemic has passed and they're willing to come back to work or get vaccinated. It's a tough decision to make. That's why I think folks are really leaning away from mandating. We can't mandate our customers. I cannot imagine any of you having a sign-up sheet out front that says, we will not allow you in our property unless you show me a vaccine passport.
And then we run into the issue of how do you validate that vaccine passport, right? We're still trying to figure that out. So we're going to learn a lot from the airlines, and the EU is trying to figure that out as well. So we're going to get hopefully some information and insight as everything evolves. But like you said, we're hopefully the EEO, somebody's going to come up with some information for us around these topics. Well, listen, I was going to
say, Stephen, I think a more practical issue that I would urge you all to focus on is, how are you going to collect vaccination information from your employees? First dose, second dose, full dose, fully vaccinated. How are you going to get it? How are you going to maintain it? And how are you going to keep it confidential? And how are you going to use it? I would say that's a...
And Stephen, just to add to that hypothetical, don't forget a number of states have outlawed vaccine passports, and Texas being one of them. If the hotel, for example, has any state business, they would fall under that mandate where they wouldn't be able to ask the guests whether or not they've been vaccinated. So even if we wanted to, we wouldn't be able to do so.
Thanks, Justin. That's a great point, and I did not realize that it included private businesses that have state business. Wow. So that's interesting, because Nick and I were talking about this issue before with the Texas governor making that decree. And Nick, if you don't mind, for the audience, I want to make sure I get it right. I think you said that OSHA will not preempt state agencies, right?
As far as for the state agency employees go, OSHA can preempt a state agency rule that applies to private employers, but OSHA generally does not apply to state employees that work for the state agencies.
Right. Wow, what Justin just said, I think, throws a little bit of a wrench into the private employer perspective on this.
Well, I think the governor's order wouldn't preempt a hotel or a restaurant from having a policy regarding employees and vaccination, but it would apply to the public at large.
Right. Okay. Yeah. No. Thanks for clarifying that. But I think that's a great point. Okay. We could talk for a long time about vaccines. If you have other questions, please load them in the chat. We've got a few more minutes. And I want to get to another question with Andria real quickly, because I know many of you are struggling to find employees, and many of you are turning to staffing solutions, third-party staffing solutions. Andria, just relatively quickly, down and dirty, what are some of the challenges we need to think about in these staffing solution contracts?
very first piece of advice is you should hesitate to sign the staffing agreement that they put in front of your executive housekeeper or your general manager. It is not complete enough for your protection, and I see no harm in either modifying the version they give you or using your own. And it doesn't have to be complicated, but it needs to protect you in a number of areas. If you're going to use a staffing agency to supplement your workforce, you need to make sure that the staffing agency commits to you that they will pay employees properly. If they don't pay them minimum wage, overtime, or follow the wage and hour laws, you are likely going to be considered a joint employer, and they're going to come after one of the two of you for that money. So you need to have a provision that addresses their obligation to pay them properly and indemnify you if they don't. Secondly, another important area, a number of areas, but these are the highlights, and that is immigration compliance. You need them to commit that they are in compliance with all the immigration laws, and that upon reasonable request from you, that they will provide copies of documentation, I-9 forms, for example, that prove that their staff, that those that they're sending on your property are authorized to work in the United States. Not that you need their I-9 forms right away, but if you hear about a concern or you start to get word that there may be a problem with the work status of these employees, you want the ability to go to your contractor and ask for proof that their employees are authorized to work here. But you do need some indemnification provisions built into that contract, which are not likely to be there in that one-page document that they hand to your executive housekeeper and ask them to sign. I want you to be really cautious, make sure that you've got the right protections in those agreements. And it does not have to be complicated.
Listen, that's very helpful. Thank you very much. We've got to wrap up and get prepared for the next session, but I want to, if anybody has any additional questions, please in the chat or feel free to just chime in. But I was remiss, when Justin chimed in. Justin Bragiel is the general counsel for the Texas Hotel Lodging Association and a real thought leader across the country in laws that impact the lodging industry. So thanks for joining us today, Justin, and thanks for your thoughts on that topic. Andrea, Nick, you'll see the survey that Taylor just put up. Do you need CLE for this session? Just a simple yes or no. But Andrea and Nick, while we're wrapping up, any final thoughts around the things we've talked about today?
No, I think my final thought is really what we started with, and that is let's not waste the energy and the commitment that we made when we started reopening and educating ourselves and putting safety and other protocols in place. Let's not waste all that energy and money and time and loosen up too early. The plaintiff's bar is just now getting back on its feet, and they're looking for COVID-related claims, and they're finding them. And so don't be a victim to that.
Very good insight. Nick?
Yep, I would just echo that. We're not through this yet. Kind of don't stop running in the home stretch. So just make sure you're continuing to protect yourself and your employees. So if that way you are protected.
That's great. Nick, real quick, just something popped into my mind. As Andrea mentioned, the joint employer thing, and everybody's trying to kind of avoid that, right? And especially in the franchise circumstances, which a lot of our attendees are involved in that type of relationship. But Nick, I think the answer is pretty clear, but I want to make sure when you're talking about the OSHA logs, when you're talking about the policies and procedure programs that you talked about putting together and melding, right? So that if OSHA does show up, you can hand it out. This needs to be communicated to every single franchisee, correct? Because it's based upon their physical location. Is that a fair way to put that?
Yep, that's correct. Each location would be treated separately, and each location would need to have their own set of OSHA logs, correct? It's for each work site.
And what are you seeing in terms of kind of the joint employer concept between the franchisor and franchisee with OSHA type violations? Are you seeing the franchisor brought into those concerns or government claims?
From the OSHA side, that's pretty rare. They mainly are looking at who's controlling the day-to-day direction of the employees. So it's pretty rare on the OSHA side, but it is possible.
It is. Okay. Well, with that, ladies and gentlemen, let's say thank you to Andria and Nick, Fisher Phillips Law Firm. Be sure to tune into their website. Great information. Guys, can't thank you enough for kicking us off. Fascinating conversation.